In a historic U.S. Supreme Court decision, justices ruled Thursday that much of eastern Oklahoma has been, contrary to the state's long-standing belief, part of the Muscogee Creek Nation Reservation. The McGirt V. Oklahoma ruling clarified that the tribal lands, covering millions of square acres including Tulsa and the surrounding area, were never officially dissolved when Oklahoma achieved statehood. In a narrow sense, this means that Jimmy McGirt, a 71-year-old Creek Nation man serving a 500-year state prison sentence for what sex crimes against a 4-year-old child, was wrongly convicted of state charges and must be retried in federal courts since states typically lack jurisdiction over major crimes committed by Native Americans, or against them, on reservations. But the decision could have much more far-reaching ramifications, potentially impacting thousands of current or future criminal cases, tax and regulatory laws and a swatch of agreements between tribes and the state. Though state, federal and tribal leaders said in the aftermath of the ruling that they are working together to understand and resolve significant jurisdictional issues raised by the case, court filings show a deep divergence of opinions on the magnitude of impact. While the state warned of the chaos waiting in the wings if Oklahoma lost the case, tribes and others opposing the state downplayed those concerns. Here's how the state, others and the Supreme Court sees the ruling playing out in the coming weeks and months. How many convictions could be overturned? During oral arguments before the court this May, Oklahoma Solicitor General Mithun Mansinghani told the justices there are over 1,700 inmates in state custody who identify as Native American and were convicted of crimes that occurred in what is now recognized as tribal territory in light of Thursday's ruling. He added that those, along with another about 1,700 cases that occurred where the victim was Native American, can be overturned. So the state presumptively would not have jurisdiction over those people and have to release them, he said. McGirt's lawyer, Heath Gershengorn, argued in his opening brief that there is no reason to believe the state's back-of-the-envelope alarmism about existing convictions. He said procedural and statutory hurdles will prevent the vast number of inmates from attempting to have their state convictions overturned. And if they do, he said, it will be a risky proposition since they are unlikely to go free while they wait for a federal trial and could face longer charges in the end. Success will subject them to federal prosecutions, which often yield harsher sentences, he wrote. What about future cases and law enforcement? Attorneys representing or supporting Oklahoma's position also argued that losing the case would throw future convictions into jeopardy and add confusion about which law enforcement agencies has jurisdiction over a given area.